Yes, good evening to everybody. Welcome to the class of the PGLCET 2022, and today is the law of crimes and thoughts MCQ. Yes, I read what I posted on the screen. Anyone read what I posted on the screen? I said read what I posted on the screen. Are you hearing me?
The percolation of water is not a form of actionable nuisance was held in the case of A. Jones versus Lovox Quarries Limited, B. Bradford versus Pickles, C. Glasgow Corporation versus Taylor, D. Fitzgerald versus Slade.
Sir, option C, sir, Glasgow Corporation versus Taylor.
Option B is the correct answer. Bradford versus Pickles. Bradford Corporation versus Pickles.
Okay, supplementary question. Even though you are having the bad motive or intention, but you are not injuring the somebody's right, at that instance, it is not actionable under the tort. But when you come to the Glasgow Corporation versus Taylor, it is a public garden. In the public garden, there are many shrubs are there, but one of the shrub is said to be the belladonna. It is a bush, but it doesn't have the fencing, and there is no signboard also, because it is a poisonous. The belladonna will be look like a cherry, and one of the small boy, he put the hand and he picked it and he ate. Consequently, he died. So they filed a case against the Glasgow Corporation. They did not keep the signboard, number one. Number two, they did not keep the fencing around the shrub because it's a poisonous, which fruits are look like cherries. And hence, when you say the tort, an act or omission, in the omission it will come. What is the omissions? Number one, did not keep the signboard. Number two, there is no fencing. So that is the Glasgow Corporation versus Taylor case law. So
Yes, sir.
omission is supplementary. They can ask the question whether it is an act or omission, or whether it is a tort or no tort. Next, 14th question.
The propounder of pigeonhole theory is A. Salmon, B. Winfield, C. Clark and Linsell, D. Austin.
Salmon, sir, option A.
So option A is the correct answer. Salmon propounded this pigeonhole theory of thought.
Yes, supplementary. There are two theories are there. Number one, pigeonhole theory. It is nothing but like a post office. There are sorting boxes are there. So each offense is one box. They wrote it like false imprisonment, libel, slander, malicious prosecution, and so on and so forth. If any box, any offense will not fit into this pigeonhole, then it will not said to be the offense. But Winfield says torts are not finite, it is infinite, means infinity. There are many types of the torts there, because now the new torts has emerged over there is cyber tort. Earlier we did not know the cyber tort, but we know it now. Cyber tort is there, like phishing, hacking, stalking, cyber spotting. These are all the new type of the electronic offenses, and hence they say infinity will be there. So both are right in their own theory. Salmon also right in his own theory, because he says each pigeonhole is such a capability would be there. We can make a division in it, again we can insert it. But the Winfield says it is infinity because torts are innumerable. So the two theories are the same. The example which is given over by there is Salmon says, for instance, take an example, tree. Whether tree is animate or inanimate,
It's animate.
it is animate because it grows from
It has
germination
life.
to the shrub to that, it will grow branches and it will grow. But in the same manner, tree is inanimate also because it will not make the movement. A movable things always make the movement, but there is no movement in the tree. Hence, both are right in their own perspective. One perspective is animate, another perspective is inanimate, and hence both theories are right. Salmon theory also right, and the Wimfield theory also right. And that's the reason in the Wimfield book you could not see L-A-W, law of tort, T-O-R-T, tort. There is no S. But when you see the Salmon book, you find L-O-T-O-R-T-S, torts. And tort is singular and torts are not plural. No. So the school of thought says tort, T-O-R-T, tort is infinity and the T-O-R-T, torts is a pigeonhole theory. So you could see on the cover page, if you happen to see the law of tort book, some books are having the T-O-T tort, some books is having the T-O-R-T-S torts. Is it clear?
Yes, sir.
Okay, next. 15th question.
Now, 15th question is, ubi jus ibi remedium means A, where there is a right, there is a remedy. Option B is, there is no remedy without a wrong. Option C is, there is no wrong without a remedy. Option D is, there is no right without a remedy.
Sir, option C, sir. There is no wrong without a remedy.
Yes, option C is the correct answer. There is no wrong without a remedy. This
Supplementary.
means.
What are the three trio maxims? I repeat, what are trio means three, T-R-I-O, trio maxims in the law of tort.
Yes, sir.
If you don't know, you say Masan.
Damnum sine injuria, injurious sine damnum, and ibi jus ibi remedium.
You are right. These are the three trio maxims. And hence we can say supplementary questions. What are the trio maxims which will not odd man out? So he may give the another one, Q facit per alium facit per se. He who does through the others does himself. Under vicarious liability it comes. So supplementary question they may ask in such a way also. Is it clear?
Yes, sir.
Very good. 16th question, go ahead.
Now the 16th question is, the maxim injuria sine damno has been explained in A, Jana versus Stevenson, B, Winterbottom versus Wright, C, Ashby versus White, D, Lumley versus Guy.
Sir,
The
should be
maxim
C, sir.
injuria sine damno, it should be kept in actually quotation marks, injuria sine damno.
Okay, yeah.
C, sir. Option
Always
C.
the Latin maxim should be in italics. Supplementary. Donegal versus
Ashby
Stevenson, what it
versus White.
says? Yes,
Ashby
answer here
versus
is C is the
White
right answer.
correct answer, sir. Yes.
Sir, 16th question, C is the right answer because
Yes,
there is
sir.
a legal injury is caused without any damage. And if you happen to see the Ashby versus White facts of the case law, and he wants to franchise his vote, cast his vote, but the returning officer did not allow him because he saw a different manual where his name was not found, and hence he did not allow him to cast the vote. But to whom that he would like to cast the vote, he won the election with the bumper majority. But still he says, my legal injury is caused, even though the person to whom I am going to vote, he won with the bumper majority, it doesn't make any damage to me. But it is the injuries happened, and hence it is the injuria sine damnum. And a supplementary question they may also ask, Donegal versus Stevenson, what this case law says. There are three principles are involved in this case law. Anyone?
No, sir. Don't remember, sir.
Love your neighbor. That is the one principle. Second principle is privity of contract is a fallacy. There is no privity would be there in the tort. And third, it is the development of the negligence from this case law. So three principles are involved. This is nothing but a ginger bees case law, and where a snail, a decayed snail was in the tumbler of the fiancée when she consumed the first tumbler. Second time we poured it because the bare body is opaque. We could not see with the physically what is floating inside. And hence they say novus actor intervenens. This is another maxim will be used over there. There is no break of the chain from the manufacturer to the consumer. And all the intermediates are only the postman's. And they did not open it. It is a sealed bottle. It is opened in the front, and in they poured it. The second round they found a decayed snail would be there, and she was omitted, and she was admitted, and compensation would be paid. The reason is a manufacturer would be held liable even though he doesn't know, means the manufacturer doesn't know who is the consumer. So there will not be any privity would be there. In the contract, there is a privity would be there. Means he should be a party to the contract. So that was the Donegal versus Stevenson. Three principles are made. But the Winterbottom versus Wright case law, they say there should be a privity, then only a person would be held liable. The decision in the Winterbottom versus Wright case law is overruled in the Donegal versus Stevenson case law. Is it clear?
Yes, sir.
Yes, sir.
Good. Next, 17th question.
17th question is liability in tort depends upon A. Quantum of damages suffered, B. Involvement of intention, C. Infringement of legal right, D. Effect on public interest.
Sir, quantum of damages suffered.
No.
That is not correct answer.
Liability in tort depends upon infringement of legal right.
Yes, C is the correct answer. Option
Yes.
C is the correct answer. Infringement of legal right.
Supplementary. How many types of the liabilities you know?
Liability. No, sir.
Joint
It's just
liability,
Yeah.
vicarious
Several
liability,
liability.
Vicarious
mass
liability.
liability, product liability. These are the
Absolute
generally
liability.
main liabilities are there under the tort. Next question, 18th question.
Where the plaintiff in action sues for a predetermined and inelastic sum of money, he is said to have claimed A. Unliquidated damages, B. Confined damages, C. Liquidated damages, D. Unlimited damages.
Sir, confined damages.
No.
Liquidated. Means predetermined. Okay. Liquidated damages, sir. C.
It's option
And I
C
made
is
the
the correct
distinction
answer.
between the contract and the tort. In the contract, the amount is ascertained, but the tort, the amount will be later, it will be counted, depending on the slots available over there. It is not a certain amount. And hence,
Yes.
if you want to see the answer for this one, when it is ascertained, it is said to be the liquidated damages. When it is not
Already
ascertained,
predetermined. Already
Unliquidated.
it is determined, so predetermined and inelastic means they cannot be expanded.
that means
Yes.
liquidated. The right answer is
Yes.
Option C,
C.
sir. Liquidated.
yes for 18th question. Next,
19th question is in a branch of contract,
breach.
damages may be A. Liquidated, B. Unliquidated, C. Liquidated or unliquidated, D. None of the above.
Please note
No,
here that in a breach of a contract.
Yeah, means liquidated, sir.
Yes.
No, yeah.
No, liquidated
No.
is the right answer. Predetermined,
Yes,
Option C
ascertained.
now we have discussed. And the previous question almost this
Yeah,
is related.
it is covered over there.
Yes, sir.
Yes.
20th.
Now, 20th question is, who among the following holds that there is no law of tort, but there is law of torts? Winfield, Salmon, Austin, Blackstone.
Winfield, sir. Option A.
I
Option
told
B
you
is
already,
correct
Winfield
answer.
book, TORT is there. In Salmon book, TORTS is there.
Sir, this last torts, yes is there, that is related to Salmon. So
That is related to
that-
Salmon. If no S
That
is
is-
there, it is related to the Winfield.
Winfield, okay.
And Salmon theory is pigeonhole theory, finite theory, But the Winfield theory is infinite or infinite theory. Thoughts are unlimited. That is the dogma of Winfield. And his Solomon thought are ascertained and filled, and we can incapacitate in any pigeonhole. Now, 20th question.
Yes.
Now, 21st question is, the
21st.
main supporter of the theory that it is a law of thought and not law of thoughts is A. Winfield, B. Solomon, C. Fleming, D. Houston.
Option A, sir, Winfield.
Option A is the correct answer, Winfield.
Because we gave the feedback so much, I think you are not you are in a
22nd
position to
question is-
give the answer for this one.
Yes, I can remember it, sir.
22nd question. Gloucester Grammar School case explains A. Injurious sign damno, B. Damnum sign injuria, C. Respondent superior, D. Remoteness of damages.
Sir, option A, sir, injuria sine damno.
I told you that Ashby versus White is injuria sine damnum. Gloucester Grammar School is damnum sine injuria. A damage is caused without any legal injury. And here, another public school, grammar school is opened over there with a less tuition fee, with more infrastructure, with good lecturers. People will take in the TC from the old grammar school and joined in front of the another school whose partner is opened it, and hence he suffered the revenue lost more of the first grammar school man. The newly opened he's got the much revenue because of the many students took the TC from there and joined in his school because the tuition fee is less and the good infrastructure and a good teaching staff was there. And I always in business competition is allowed. Hence there is a damage is caused over there, but there is no legal injury. Hence the Gloucester Grammar School,
There is
and he is not
no-
going to get any compensation.
Yes, sometimes I get confused between these two. There is a reason I could not able to answer it
There
properly.
is no infringement of legal right here.
Yes, damage has done, but no infringement of legal right.
Yes.
Damage and injuria. Yeah.
Damnum sign injury.
Yes, sir.
Damage without injury.
Yes. In this way, I will
Without
get
injury means legal injury.
But in HP versus White, there is a legal injury is caused because the returning officer did not allow him to cast his vote. And he is having the right to vote. Even though there is no damage is happened over there. The reason is to whom that he would like to vote, he won with the bumper majority. Is it clear?
Yes, sir.
Yes.
Next.
23rd question is malice in law means A. Wrongful act done intentionally but unjust cause. B. Wrongful act done intentionally with just. C. Wrongful act done intentionally with good motive. D. Wrongful act done intentionally with evil without just cause or excuse cause. Cause and excuse motive.
Sir, option B, sir, wrongful act done intentionally with just.
No.
Then it should be D, sir, wrongful act done intentionally with evil without just.
Option A is the correct answer.
Wrongful act done intentionally but unjust cause.
Yes. Wrongful act done intentionally but unjust cause.
Okay.
Wrongful act done intentionally but the cause is unjust.
Okay.
That is malice. 24th question. The decision in Ashby versus White furthers A. Solomon theory, B. Winfield theory, C. Both A and B, D. Neither A nor B.
It was related to uh
Ashby versus White.
yeah, I mean strict
The legal
liability.
right is violated.
Yeah.
And this propounder of this theory means any legal right is violated over there and there should be a remedy. That is the Winfield theory. Of course, here both A and B right because both the theories will give the same sense.
C
Here
is the
the
correct
answer might
answer.
be
Both A and
both
B.
A and B.
C.
Yes, C is the
Okay,
right
so
answer.
settlement theory
Because
is
both the theories will give redressable. There is neither a breach of a contract, neither a breach of a trust, says Salman. So both A and B is the right answer for that one.
Yes. 25th question. Voluntary non-fit injuria is a defense in an action for torts. B. A ground for initiation action for torts. C. Not a defense in an action for torts. D. Both B and C above.
option
Voluntary
A, sir.
non-fit. So option A is the right answer. A
Yes,
defense in an action for a
torts.
defense is an action for torts.
I will give the explanation for that one.
Yes,
Voluntary
sir.
means voluntarily accept to undergo the injury. For instance, boxing. In
Yes, sir.
boxing, there is a probability that you will be get injury and your eyes will
Yes,
be
sir.
bruised or you will
Yes,
get
sir.
some other thing, your blood is clotted. Do you file a case against him? Answer no. Reason is
No, sir.
voluntarily you accepted to undergo. But if he did anything wrong, way of punching, the rule says you should not punch on the stomach.
Yes,
Below
sir.
the belt you should not punch. That is the wording is there. Below the belt means lower part. At that instance, if you punch it, naturally it is against the rule. And hence,
Yes.
voluntary not fit injury will not be applicable over there. Next.
26th question is the maxim voluntary non-fit injuria applies A. When one is compelled to do work despite his protest. B. When one adopts a risky method of work under his own free will. C. When one works under constant risk of life, but during the accident he was not warned, though he is aware of the risk. D. Both A and C.
Both A and C, sir. D, sir.
No.
When one is compelled to do work despite his no, no, no. It should be C, sir.
No.
The answer is option B. When one adopts a risky method of work under his own free will, with his own free will, he is in the boxing ring.
Okay, I will give the explanation. Suppose if you are working in the underground mine, you know that the roof, if it is loose, it may fall. But do you think that in the underground mine, the people will not work now? For instance, if the Singarani Corners Company Limited, there are underground mines are there. In the underground mines, there is a lot of risk could be there, but still they are working. Do you think that they are voluntarily given the consent to undergo such a risk? Answer
Yes, sir.
is no, because those who are working underground, their allowances are very big. Number one. Number two, first they will not allow the workers. A foreman would be there and he will go and he will check whether the roof is a proper way or not. If the roof is not proper way, they will keep the iron rods and some wooden logs over there so the roof will not fall over there. And that is the reason, even though you know the risk is there, but still you are working, it doesn't mean that voluntary not fit injury is applicable over there. And the beautiful case law we are here is Smith versus Baker case law. And where the quarry carrying the bulldozers in the crane and the people are working in the quarry below, and anytime the boulder may fall down, but when the crane is moving over from one end to another end, they used to give the vessel, but they have taken a lot of care also, but when boulder fall down and the employees got injured over there. But he knows that it doesn't mean that it is a voluntary fit injury would be there. There is a beautiful case law, Smith versus Baker case law. Next.
So, with his own free will, he has joined.
Yes.
27th question. The defense of voluntary non-fit injury is not available. A. If the consent is obtained by compulsion. B. If the consent is obtained by fraud. C. If the consent is obtained under a mistake. D. All the above.
All the above, sir.
Yes, option D is the correct answer. All of the above is correct answer. Next, 28th question. The scope of availability of the defense of voluntary non-fit injuria. A. has been restricted in rescue cases. B. Has been restricted by Unfair Contract Term Act 1977 in England. C. Cannot be restricted except in cases consent without free will. D. A and B above.
Cannot
C,
be
sir.
restricted
Option
except
C,
in the
sir.
case of
Uh, score-
Sheru.
Option D is the correct answer. A and B above.
rescue cases. Okay, sir.
Rescue cases, it will not be applicable. Unfair trade contract terms, it cannot be applicable over there.
Okay, sir.
Now, 29th question is, in tort, the private defense is A, not available, B, is available to protect one's person under criminal law, C, is available to protect one's property under criminal law, D, both B and C.
Sir, B and C, sir. Option D.
Yes, option D is the correct answer, both B and C. 30th question, the following are actionable torts as well as criminal offenses. A, assault, B, battery, C, false imprisonment, D, all of the above.
D, sir. All of the above.
Yes, all of the above is the correct answer. Option D is the correct answer. 31st question. Which of the following is the leading case relating to employer's liability? A, Elot versus Wilkes, 1820. B, Fetter versus Beale, 1701. C, Ferrand versus Banks, 1876. D, Bell versus Stone, 1798.
Sir, option D, sir. Bill versus Stone.
Option A is the correct answer. Elot versus Wilkes, 1820 case. In this case, there is employer's liability. Employer is liable.
Okay, sir.
32nd question. Act of state means A, an exercise of power against an alien and neither intended nor purporting to be legally founded. B, an exercise of power against his own subjects. C, an exercise of power against the alien as well as his own subjects. D, none of the above.
Option C, sir. An exercise of power against the alien as well as his own power. Option
No.
C, sir.
The answer
Then
is A, an
D,
exercise of power against an alien and neither intended nor purporting to be legally founded. This is
That is
legally, not
not
legally.
legally, else should be there.
Legally
But
founded.
Okay.
It's called act of state. Next.
Why not C, sir? Why not C, sir?
See, why not see? I will give the explanation.
Yes, sir.
In an excess of power, okay, definitely is there. Against the alien, how could a state will exercise the power without reasonable cause to the subject? But without reasonable cause also they can exercise it because that the alien country.
No, sir. Subject means your citizens.
Yeah.
Subject means citizens. Yeah.
Subject
When
means
the
citizen.
neighboring, yeah, means when the neighbor attacks, the state will definitely respond.
The reason here is without legal justification also they can make the force on the alien. But for their own subject they cannot. Okay, let me do one thing. When the war is there, they take away your vehicles. For trucks, suppose you are having the 3 trucks, they will take at least 3. Why war? When you say election, if you are having the lorries and they will ask, the collector will say, give your lorries, we will pay you money. And you are supposed to give the lorries so that the people will be carried from the collector office to the remote area where the election ballots are there.
Yes, sir.
So that is the, among them, which is appropriate, you have to choose it. And that is the, because when more appropriate is given over there, the less appropriate could be discriminated. Are you following me?
Yes, sir. Yes, sir.
When the more appropriate answer is
Third
given
question.
over there, then for appropriate answer will be eclipsed.
Yes, sir.
Like in inheritance, when mother is alive and the share will not go to the mother's mother. The reason is a far relatives will be eclipsed by the near relatives.
Yeah.
So that is the same. Next.
33rd question. An act done as act of state has to be justified. A. On positive law of the land. B. On political expediency. C. On positive law and political expediency both. D. None of the above.
Sir, option C, sir.
Option B is the correct answer. On
political-
political expediency. An act done as act of state has to be justified on political expediency.
Okay.
34th question. When two or more persons commit some tort against the same person, they are A. Independent tortfeasors, B. Joint tortfeasors, C. Either independent tortfeasors or joint tortfeasors, D. Neither A nor B.
So joint tortfeasors. Option B.
Option C is the correct answer. Either independent tortfeasors or joint tortfeasors.
Suppose
can
the
be-
two persons have collided together and caused a harm. The person who wants to bring an action, it is his discretion. Either can bring an action against A, but he can leave the B. Or he can bring the action both severally or jointly. Severally means independently, or jointly means together.
Yes, yes.
That is his discretion.
Yes.
35th
Victim
question.
discretion.
35th question. The liability of independent tortfeasors, A. Joint only, B. Several only, C. Joint and several, D. Neither joint nor several.
Independent tortfeasor, only one.
Yes, several, sir.
It is a several because you can sever it. Only one, not
Yeah.
jointly.
Yes, sir.
We can separate only a specific action. B. Several only, independent action.
Yeah.
36th question. The liability of joint tortfeasors is A. Only joint, B. Only several, C. Joint and several, D. Neither joint nor several. We have already come across this.
Yeah.
Yeah. So C, sir. Joint and several.
Joint and several.
Option C.
37th question. In Ushaben Trivedi versus Bhagyalakshmi Chitra Mandir, it was held that hurt to religious feeling A is an actionable wrong, B not an actionable wrong, C question kept open, D none of the above.
Sir, I guess option A, sir, is an
Yes,
actionable
option
wrong.
A is the correct answer.
Yes,
Is
sir.
an actionable wrong.
Yes,
No,
sir.
no, let me clear it. There is something wrong is there. Let me clear it. Do you know the Usha Bent Trivedi versus Bhagalakshmi Chitra Mandir? Actually, what is the facts of the case, love?
I don't remember, sir. I did not.
See, the Usha Ben, she is the one of the viewer of the Bhagalakshmi Chitra Mandir, Jai Santoshima. That is the movie. In Jai
Yes, sir.
Santoshima, which is produced by the Bhagalakshmi Chitra Mandir, they depicted the three women goddesses. Who are the three women goddesses?
Kali,
No.
Santoshima.
Vishnu's wife, Shiva's wife, Lakshmi, Parvati, and
Saraswati.
Saraswati. These are picturized in such a way they are jealousy to each other. That is exaggerated. And she said, Bhagyalakshmi Chitra Mandir has picturized, synchronized the movie, which is more jealousy would be shown. But they did not show, but really there would be a little jealousy would be there among them. And if you are really, your religious heart is feeling over there, you are not supposed to go and see the movie. But actually the picturation is that, yes, women are having the jealousy. So it is not an actionable wrong. So B is the
B
right
is the
answer.
correct answer. Okay, sir.
It is not an actionable wrong because
Okay.
it is a religious, really, if you see it also, Lakshmi, Parvati and Saraswati to certain extent jealousy to each other. If you say in that way, women are jealousy to each other, universal truth. I'm sorry, my mother is a woman, my wife is a woman, my sister is a woman. Okay, next.
38th question is, novus actus interveniens is related to A, remoteness of consequence, B, possible consequence, D, direct consequence, D, none of the above. Novus actus interveniens.
See, I told you this maxim in the Donegal versus Stevenson. The manufacturer manufactured the ginger beer and he has given to a regional agent. Regional agent, it goes to a distributor. And from distributor, it goes to the bar. From the bar, it goes to the bar woman. And bar woman goes to the consumer. There she opens the bottle. Here, there is no break of the chain. The chain is as it is because it is a sealed bottle, it is reached to the consumer and who is unknown. At that time, there is no new act has intervened over there. That means there is no break of chain. Now you tell me.
Direct consequences, option C. Remoteness
Option
of
A
chain.
is the correct answer. Remoteness of consequence.
See, the remote of the consequences are there because
Though
no one is
though
interfered
it is
there.
Okay,
though
sir.
it is a distant one, the relationship, there is a consequence.
Okay, I thought
The
it's a direct
manufacturer is at a distant place, but the consequence has occurred. So that is remoteness of consequence. Even then also there will be
Suppose the bottle is opened by the agent or by the distributor, then intervenience is there. He might have put a putrid smell, a decayed smell in it. But the opaque bottle, it's a sealed bottle, is open in the front of a consumer. Means there is no break of the chain. So novus acted intervenience, there is no break of the chain, and hence manufacturer is held liable. If not, the agent or a distributor or the barman, if he's opened it, and he will be held liable. Okay, next.
39th question is, if the same act done by a person results in two wrongs, a crime as well as tort at the same time, in such a case, A, civil remedy would be available, B, criminal remedy would be available, C, both A and B are correct, D, none of the above.
Sir, option C, sir, both A and B.
Option C is the correct answer. Both A and B are correct. There is civil remedy as well as criminal remedy.
For instance, you take accident. Accident is a both civil wrong as well as the criminal wrong. For the civil wrong, the injured will file a case under the Motor Vehicle Act. For the criminal wrong, police will file again the following the MV Act. But if the police case, if the victim is scot free, it doesn't bar the civil action. Even civil action will be continued. The reason is, in the criminal wrong, beyond the reasonable doubt is there. But in the civil wrong, preponderance of the evidence. Is it clear?
Yes, sir.
Damage will be paid.
Next.
40th question. Can a man lawfully shoot his neighbor's tamed pigeons if they are found damaging his crops? A, yes. B, no. C, depends on the circumstances. D, none of the above.
Depends
Can
on
a
the
man
circumstances,
lawfully
sir.
shoot neighbor's tamed pigeons if they are found damaging his crops?
No, sir.
The answer is option A, yes.
Okay,
Because
legally.
He can
they are
shoot the
tamed
tamed pigeon if they are found damaging his crop. But the
Okay,
point
tamed
is,
pigeons.
we cannot shoot the pigeon when it is eating in the owner's house. If it is eating in the crops of his every man is having a right to protect his own property. Am I right?
Okay, sir. Yes, sir.
What the
Trespass
first
by
question is,
animals. Yeah.
the maxim salus populi suprema lex. Salus populi suprema lex means A. No man is above the law. B. The welfare of the people is supreme law. C. Act of God. D. None of the above.
Sir, option B, sir.
Yes, option B is the correct answer. The welfare of the people is supreme
Supreme
law.
law.
Salus populi suprema lex. Now, 42nd question. According to Justinian, every action contrary to law is A. Liberty, B. Power, C. Damnum, D. Injury.
Contrary to law is. So liberty, sir?
Action contrary to law.
Yeah.
We
Action
have already
against.
discussed.
Yeah, contrary to law. is-
Option D is the correct answer. Injury.
You cannot cause the injury to your neighbor. It's a contrary to the law.
Okay, sir.
Even a flying kiss.
That is also legal injury.
Sir, a small request, sir.
Yes.
Can we have another half an hour session, sir, today on torts? If you have time, sir.
No, if you want, we can make it up tomorrow in the daytime
Yes, yes, sir.
or Sunday
We can-
daytime.
Yes, sir. Because I'm very weak in this torts, sir.
But I'm sure that you are not attended the classes.
It was in the first semester, sir. Means in the first semester of my LLB, I was not that much punctual to the classes.
Yeah. If a person who attend the class regularly, I'm sure that he never forget. Like you are giving the answer to the critical questions, but you did not give the answer yesterday. Who drafted the IPC? Everybody
Yes.
knows this. Lord Macaulay drafted it. Not only that, even CRPC also.
Yes, sir.
It is like a question: who drafted the Constitution of India? If you don't give the answer, it seems that you are so much weak in the attending the classes, but you are giving the critical answers sometimes.
Yes, sir. Because from first semester, second semester onwards, there was a lockdown, so we missed all the classes, physical classes.
Yeah, anyway, the time is only left. You are there, finish it up. Only few other. Let me read it. 43 question. The doctrine of vicarious liability applies when there is a dash, a relationship of the principal and agent, relationship of the partners, relationship of the master and servant, and all of the above. Shoot.
Sir, all of the above, sir. D.
Because always the vicarious liability, there is some relation should be there. Either the principal agent or the partners and other partners or the master and servant. Yes, good evening to everybody. Welcome to the class of the PGLCET 2022, and today is the law of crimes and torts MCQ. Yes, I read what I posted on the screen. Anyone read what I posted on the screen? I said read what I posted on the screen. Are you hearing me? Yes, good evening to everybody. Welcome to the class of the PGLCET 2022, and today is the law of crimes and torts MCQ. Yes, I read what I posted on the screen. Anyone read what I posted on the screen? I said read what I posted on the screen. Are you hearing me?
अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंधु गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्छल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मागे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे अहरह तव आभार प्रचारित सुनि तव उदार वाणी